Okay, we're live. We're going to finish, which I just started. It's about performance and excuse of non-performance. And at common law, the basic duty is to substantially perform all that is called for under the contract. Article 2 generally requires the adherence to the perfect tender rule that the delivery and condition of the goods must be exactly as promised in the contract. There's an obligation of good faith. The seller's obligation of tender and delivery in non-carrier cases is discussed in terms of the tender of delivery and the place of delivery. And all of this has to be reasonable, sufficient time for the buyer to take possession, might involve notice, and at a reasonable hour, and the place of delivery where it is, which is a seller's place of business or their residence, and have one. For carrier cases, we discussed the shipment contracts where the seller has not agreed to tender at a particular destination, and destination contracts where the seller has agreed to tender at a particular destination. And I had moved to the buyer's obligation to pay and right to inspect. Delivery and payment are concurrent conditions in non-carrier cases unless the contract provides otherwise. Did I get very far? Yeah, let's just start there. A sale is for cash and the price is due concurrently with tender of delivery. However, unless otherwise agreed, when goods are shipped by carrier, the price is due only at the time and place where the buyer receives the goods. Therefore, in a shipment case, the price is due when the goods are put in the hands of the carrier, and in a destination contract, the price is due when the goods reach the named destination. Installment contracts, Part B in this section. In an installment contract that is one that requires or authorizes delivery in separate installments, the seller may demand payment for each installment if the price can be so apportioned, unless a contrary intent appears. Buyer's right of inspection. Within this section, the buyer has a right to inspect the goods before they pay, unless the contract provides for payment COD or otherwise indicates the buyer has promised to pay without inspecting the goods. Payment by check, tender, or payment by check is sufficient unless the seller demands cash and gives the buyer time to get it. If a check is given, the buyer's duty to pay is suspended until the check is either paid or dishonored. If the check is paid, the buyer's duty to pay is discharged. If the check is dishonored, the seller may sue for the price or recover the goods. Part 6.3, conditions. Has the duty to perform become absolute? A contract may provide that a party does not have a duty to perform unless some condition is fulfilled. In that case, the party's failure to perform is justified if the condition was not fulfilled. Distinction between promise and condition. It's important to understand that there is a difference between whether a party is bound under a contract and whether a party who is bound has come under a duty to perform. A person is bound if there has been an offer, an acceptance, and exchange of consideration. However, the contract may provide impliedly or explicitly that a party who is bound does not have a duty to perform unless or until some specified condition occurs. In looking at the terms of a contract, a distinction has to be drawn between an absolute promise on the one hand and a condition on the other. Definitions. A promise is a commitment to do or refrain from doing something. If a promise is unconditional, the failure to perform according to its terms is a breach of contract. Condition normally means either one, an event or state of the world that must occur to fail to occur before a party has a duty to perform, or two, an event or state of the world, the occurrence or non-occurrence of which releases a party from their duty to perform. A condition is a promise modifier There can be no, that's a statement. That's a period. There can be no breach of promise until the promisor is under an immediate duty to perform. Failure of condition versus breach of contract. The failure of a contractual provision that is only a condition is a failure of a contractual provision that is only a condition is not a breach of a contract, but it discharges the liability of the promisor whose obligations on the conditional promise never mature. All right. I feel like I didn't understand anything I said in a while. So let's go back to these. Okay, we're in the condition section and we're waiting for a duty to basically vest, become absolute, to put it in their words. There's a difference between a promise and a condition. A promise is a commitment to do or refrain from doing something. If a promise is unconditional, the failure to perform according to its terms is a breach of contract. Condition normally means either an event or state of the world. Okay, so that's where we got to the state of the world statements. That has to happen before a party can has a duty to perform. Then we have the failure of condition being different than a breach of contract. And lastly, on this page, before we see a table, is the interpretation of provision as promise or condition. What determines whether a contract provision is a promise or a condition is the intent of the parties. Courts will look at the words and phrases used by the parties, their prior practices, the custom in the business community with respect to the provision, and whether performance is needed from a third party. If performance is to be rendered by a third party, it's more likely to be a condition than an absolute promise. In doubtful situations, most courts will hold that the provision in question is a promise. So here really, literally trying to determine between the two, look at the intent of the parties. In doubtful situations, most courts will prefer viewing a promise from the contract provision. Now, there's a table here. Is there a condition to a party's performance in the contract? If no, the party has an absolute duty to perform. Has the duty been discharged by performance, impossibility, impracticability, frustration of purpose, mutual rescission, release, modification, accord and satisfaction, novation, or lapse? If yes, the party's contractual duties have been discharged. If no, performance due or party is in breach. However, if there is a condition to the party's performance in the contract, has the condition been excused? If yes, we go over to the table again with all of the options there. The party has an absolute duty to perform. Has the duty been discharged by performance, impossibility, impracticability, frustration of purpose, mutual rescission, release, modification, accord and satisfaction, novation, or lapse? However, if the condition was not excused, I should say, has the condition been satisfied is the question. And you go back to looking at the ways it could potentially be discharged, or no. And if no, the party has no present absolute duty to perform. If the condition has the condition been satisfied, if the answer is no, the party has no present absolute duty to perform. So, okay, it's a condition, remember. However, if the condition has been satisfied, then the party has an absolute duty to perform. And you look again at the potential reasons for a discharge, which I read again for the purpose of trying to keep this in my memory. But performance, impossibility, impracticability, frustration of purpose, mutual rescission. That's going to be an easy one to forget. Release, modification, accord and satisfaction, novation, or lapse. Yeah, pretty much all of those are going to be hard to remember besides impossibility, impracticability, and frustration of purpose. The performance is in there. Mutual rescission, which I forget about the mutual part. Just call it a rescission. Rescission, release, modification, accord and satisfaction, novation, or lapse. That's going to be hard. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 different kinds. Good to remember because I'll just keep trying until I figure it out. Until I remember them all. So express conditions is the next big subsection. Express conditions normally refers to an explicit contractual provision. It is an express statement in which the contract providing that either 1, a party does not have a duty to perform unless some event occurs, fails to occur, or 2, if some event occurs or fails to occur, the obligation of a party to perform one or more of his duties under the contract is suspended or terminated. Conditions of satisfaction are common express conditions. Promise or satisfaction as condition precedent. Many contracts include an express condition that the party will pay only if satisfied with the other party's performance. Because it is a condition, the promisor is under no duty to pay unless they are satisfied. And mechanical fitness, utility, or marketability. In contracts involving mechanical fitness, utility, or marketability, for example, construction or manufacturing contracts, a condition of satisfaction is fulfilled by a performance that would satisfy a reasonable person. If it is therefore immaterial that the promisor was not personally satisfied if the reasonable person would have accepted and approved the performance tendered. And this is for things that are involving mechanical fitness, utility, and marketability, which the example we use is paving a driveway. Whereas the promise or satisfaction of condition precedent can also be of the kind of personal taste or judgment. If the contract involves personal taste or judgment, for example, portraits or dental work, a condition of satisfaction is fulfilled only if the promisor is personally satisfied. But note, even if the condition requires some personal satisfaction, a promisor's lack of satisfaction must be honest and in good faith. Thus, if the promisor refuses to examine the promisee's performance or otherwise rejects the performance in bad faith, the conditions of satisfaction will be excused. Satisfaction of third party as a condition. Construction contracts often include a condition requiring the satisfaction of the owner's architect or engineer. When the satisfaction of the third person is a condition, most courts require the actual personal satisfaction of that person. However, the condition will be excused if the third party's dissatisfaction is not honest and in good faith. Now C, when purpose of condition is to benefit one party, when it is clear that the purpose of a condition is to protect or benefit only one of the parties, the other party's duty will be subject to the condition. And classification of conditions, there's condition precedent, condition concurrent, and condition subsequent. Condition precedent is one that must occur before an absolute duty of immediate performance arises in the other party. A condition concurrent, conditions concurrent are those that are capable of occurring together and that the parties are bound to perform at the same time. For example, tender of deed for cash. Thus, in effect, each is a condition precedent to the other. And condition subsequent. A condition subsequent is one that, when it occurs, cuts off an already existing absolute duty of performance. Conditions, time of occurrence. This is a table talking about the type. whether it be condition precedent, condition concurrent, condition subsequent. It gives a definition, the effect of occurrence of the condition, and an example. Under the definition of condition precedent, this condition must occur before performance is due. The effect of the occurrence of condition is that performance is due. For conditions concurrent, conditions occur at the same time, or to occur at the same time. The effect of the occurrence of the condition is if one condition has occurred, performance of the other is due, and condition subsequent, condition cuts off already existing duty. The duty to perform is excused. And I'm going to skip through the examples. So constructive implied conditions. Constructive conditions of performance. The most important and common implied condition is that the duty of each party to render performance is conditioned on the other party either rendering their performance or making a tender of their performance. Constructive conditions of cooperation and notice. Constructive conditions of cooperation and notice are common. Under constructive condition of cooperation, the obligation of one party to render performance is impliedly conditioned on the other party's cooperation in that performance. Also, it's often a condition to one party's performance that the other party give notice that the performance is due. A condition of notice is most commonly applied where a party couldn't reasonably be expected to know a fact, for example, need for repair, that triggered the duty to perform unless otherwise was given. So constructive condition of cooperation and notice is part of these constructive implied condition section, which was defined as the most common condition is that the duty of each party to render performance is conditioned on the other party either rendering their performance or making a tender of performance. So order of performance. The courts sometimes imply constructive conditions relating to the time for performing under the contract. Simultaneous performance possible. Conditions concurrent. If both performances can be tendered at the same time, they are constructively concurrent. Thus, each is condition precedent to the other. Also, or so, absent excuse, each party must first tender their own performance if they wish to put the other under a duty of immediate performance that would result in breach if they fail to perform. One performance takes time, conditions precedent. If one performance will take a period of time to complete while the other can be rendered in an instant, completion of the longer performance is constructive condition precedent to execution of the shorter performance. Next section, effective condition, equitable remedy. If the contract is not enforceable due to a failure or occurrence of a condition and one of the parties had fully or partially performed, they can usually recover under unjust enrichment theories, although the measure of damages in that case may be less advantageous than the contract price. And next section, have the conditions been excused? A duty of immediate performance with respect to conditional promise doesn't become absolute until the conditions, 1, have been performed, or 2, legally excused. In analyzing a question, if the facts don't reveal performance of the applicable condition precedent or concurrent, look to see whether the condition has been excused. Exclusive conditions can arise in a variety of ways. It looks like the first is exclusive condition by hindrance or failure to cooperate. There is also excuse of condition by waiver or estoppel. Within that section, you'll see estoppel waiver, election waiver, conditions that may be waived, waiver of installment contracts, right to damages for failure to condition, and then the following section will be exclusive condition by actual breach. On page 88, and I'm going to navigate back to page 88, but for the moment, I just wanted to see what else was here. Exclusive condition by anticipatory remediation is the next piece of information on page 90. followed by executory bilateral contract requirement. Anticipatory repudiation must be unequivocal. Effective anticipatory repudiation. Treat the anticipatory repudiation as total repudiation and sue immediately. Suspend their own performance and wait to sue until the performance date, and treat the repudiation as an offer to rescind, and treat the contract as discharged, or ignore the repudiation and urge the promisor to perform as, but note that, repudiating party, to perform, the non-repudiating party is not waiving the repudiation. They can still sue for breach and are exercised in performing unless the promisor retracts the repudiation. Retraction or repudiation is the next section. Excuse of condition by prospective inability dash unwillingness to perform is the next section. So I just went through titles on page 90 and 91. There will still be repudiation discussed on 92. And in 93, we're looking at divisibility of contracts. Page 94, a new topic, has the absolute duty to perform been discharged. There's a lot of ways to discharge. Probably on the next following 2 pages, so it's getting kind of long. Then navigating fairly far away from page 88, where I believe I am right now. Or when I started looking, and my computer appears to maybe completely have frozen. And we are time checking in at 22 minutes. So back to this outline. I can't see anything, so outline froze. And all right, we're back. Not getting out of anything. Discharge by accord and satisfaction. Substitute a contract. Partial discharge by modification of contract. Those are all some sections on page 96 and 97. Requirement of consideration is on page 98. Distinguish from modification. Sometimes an accord is difficult to distinguish from a modification. So that's what we're doing, is differentiating those two things. And discharge by novation, by impossibility, impracticability, or frustration. And there's a lot. There's going to be a lot. Concluding. Those are 10 straight pages at least. 11, 12, wow. Past performance prior to impossibility, quasi-contractual recovery, specific damages, death or physical incapacity, supervening illegality, subsequent discretion of contractors, subsequent matter or means of performance, compare contracts to land, specifically required, something about subject matter. And my computer's froze again, so I don't think I'm getting through this right now, especially because I'm falling asleep too.